And we're live.
Hello, everybody out there in the world. I'm Mike Sullivan, and I want to welcome you to our webinar today on Cal OSHA's sudden new COVID-19 regulations. What happened was last week, all of a sudden, well, it wasn't all of a sudden if you were watching, but for a lot of us, all of a sudden, OSHA issued a whole bunch of regulation. I mean, page after page after page about all the different things that employers have to do in the COVID crisis. It's a lot, and it's effective immediately, and it's supposed to be approved today. So we hurried up and we analyzed it, and we published a report on it last week, and now we're going to give you the whole thing. We have a lot of people with us here today. Give me the next slide, Lisa. There we are. There's four of us. The good-looking people come first.
I was just looking at myself in the Zoom, and I think I will lose the rate that room. My little office is looking very pathetic.
Well, we're all working from weird environments these days.
And
we have Eric. Well, go back.
oh, sorry.
We got Eric. DeWan
Everybody
is the managing partner of our employment law section, and Lisa Aguiar, who also works in our employment law section and did the main analysis and workup on this. So they're going to be doing most of the talking, almost all of the talking, and
I hate that.
moderate. I can't always do all of the talking. And then go to the next slide and show you the two people that are here to ask the stupid questions. I am there on the left. I'm Mike Sullivan, and that is Janey Nethery. And Janey's our executive director. She used to be a VP at a major TPA, and we recruited her to come in and run the law firm. And so we thought Janey could help out because she is the one who's going to actually have to implement this stuff in our law firm. And so as we're brainstorming going through this, and she may have some practical questions to ask, she thought maybe she could contribute something. So hello, Janey.
Good morning.
All right. What's next? Okay, so this is a presentation of Sullivan on comp. And just to clarify the relationships here, I'm the general managing partner of Michael Sullivan and Associates. But I'm also the primary author of Sullivan on Comp. And if you're listening to this, you're probably a subscriber to Sullivan on Comp. Now, normally our webinars on Sullivan on Comp only go to our subscribers, but because this is such a big deal, we've been opening up our COVID webinars materials to the whole world. And so the whole world is on this one. I don't know, last count we had well over 1,000 people. So, I mean, people are really interested in this information. So we know we had to help. So we're just going to open it up to everybody. The law firm has offices all over the state. And but today I'm going to wear my Sullivan on Comp hat, and we're going to be neutral, and we're going to just try and present the information and the laws and the considerations and the issues and what everyone might think about them, rather than advocating would usually as a defense firm. A little bit of advertising before we get going here. We have done a lot of webinars. In fact, this is number 19 in our series, and you can see here on this slide, the first bunch we did here, the burning issues, the claim form, TD, when is it work related? Go to the next one, Lisa, psych injuries, and then return to work. And, we have tried to answer, we even had one here with Jake Jacobsmeyer, who was in a coma with COVID for a month. That was really interesting. A doctor, the developing medical landscape, and finally up until today on these new, well, I guess COVID-19 update number 19 is not on here, which is today.
Yeah.
But 18 was the 685. So we're going to do another one 2 weeks from today, and it's going to be on the vaccination and what it looks like and how it's going to pan out and the issues that are going to arise in association with distributing and vaccination. That's going to be really interesting. We'll send you guys a big advertisement on that in short order. And then this last advertising slide is about our book. So we wrote a big fat book. It's an ebook. If you printed it, it'd be about 300 pages long. And it tries to answer all of the questions and address all of the issues that pertain to COVID-19. As they arise, we modify the book. Any question we can think of, we try to put the answer in there. It's really thorough. And if you want to, you just go to sullivanattorneys.com, you download it, bookmark it, and then you can just use it. We're I don't know if it's still up to these numbers, but we're close to 1,000 people a week looking at this. We're hopeful that it is helping to educate the industry as we go along. And like I said, almost every day we do something to it to make it better. So really proud of it. Hope it helps you. I also wanted to say a couple other introductory things before we jumped into the material. One is that if you have questions that you want answered, then there's little buttons on the bottom of your Zoom, right? So there's a chat, but there's also a Q&A. If you go to the Q&A, then I'd appreciate that. And what I'll do is I'll rudely interrupt the people who know what they're talking about on this call with questions that I think may be pertinent to what they're talking about. And we'll do that. I wanted to also point out that there's been a lot of legislation in the past, particularly 1159, the presumption bill, and 689, the bill on requiring employers to notify a report. This isn't about that. This is supplementary to that. So you got to realize that this is just a whole nother level of burden on the employers in California. And I'm not saying that in a critical way, it shouldn't have been, but I'm just saying that employers have a lot more to do, but it doesn't replace what they already had to do with 1159 and 689. And we have webinars on those and write-ups on those, and it's in our book. So we're available to tell you all about it, but it's not that. Let's see, what else did I want to say? We are going to create a template. One of the things that's required here, Lisa and Erica can talk about it, is that each employer has to have a plan, a written plan, COVID protection plan. And it's a lot of stuff that has to go in there. And so we're creating a template, and Lisa and Erica will have it done by Friday. And that should help employers to create their own plan by filling in the blanks and using our template as a basis for it. So I just want to let you guys know that that's going to be available to you by the end of the week. We'll post it on our website. We'll send an email to everybody, let them know it's there. And hopefully that'll help you out a lot. You know, after 689 came out, we did a sample letter. You have to do a notification letter to all your employees if they're exposed. And so we did a sample letter, and it's on our materials too. But we're going to do this again. Actually, as we've gone through all these COVIDs and we've done all these webinars and all this writings, we've done a whole bunch of templates and guides and one-page, reference sheets. And those are all in our materials. And so I wanted to mention that, and this is going to appear in your chat box now as I talk about it, as I understand it anyway. There's 3 different links here that you may find useful. One is a copy of today's slides on the PDF. So if you click on that, you can download it, and then you can print it out if you want to for future use, or follow along today with paper. Another form that's being put in the chat box right now is the state bar evaluation form. So if you would kindly fill that out, we'd be appreciative. We always like to hear how wonderful we are. Especially Eric, he's got a very fragile.
Sure. If you have anything negative to say, you don't have to fill it out.
I'm just kidding. I'm the one with the fragile ego. But anyway, the third one is a link to all the COVID resources. So if you go there, all of our one-page sheets, our samples, everything that we use that helps you implement the COVID requirements in there. And so that's it. Those are the 3 things that I wanted to mention that are available to you right now. And like I said, if you have any questions, please go to the Q&A box, and I will jump in there and interrupt Lisa and Eric and Janey. So I think that was all I have to say here as a matter of introduction. So Lisa and Eric, why don't you take the ball from here?
After you, Lisa.
Will do. Well, thank you everybody for attending and attending on the Monday following a holiday. We do appreciate it. So what we're going to talk to you about today are the new Cal OSHA safety regulations. They are 22 pages of detailed guidelines and requirements that employers must implement immediately once the OLA, the division, the Cal OSHA division, approve these regulations, which we expect to happen today. They seem lengthy, they seem difficult, and in some respects they are, and in some respects it's new information, but in a lot of respects it's simply reiterating what we've been telling you already, and what you're already required to do. What these regs do is require that you write them down, that you put them in a program, that you train your employees. And so we're going to go over all of that today. Hopefully we can answer some questions. Some of it is not yet clear, but we're more than happy to talk you through it, and how we think some of this is going to pan out. So these were initially approved on November 19th, 2020, and because they are emergency regulations, they will be in effect for 180 days unless they are renewed, and they may be renewed. I think that's going to depend on the status of the coronavirus, the status of vaccines, and what the workplace looks like in 6 months from now. So all we are waiting for in terms of these to be effective is for the OLA to sign on the dotted line. Again, I checked this morning. It's not been signed yet, but we expect that it will be today. And if you want to take a look at those regulations, all 22 pages, we've got the link up here for you as well.
Or you can look at the nifty summary done in our ebook that's on our website. Which is
Absolutely. We have summarized it there in multiple pages and in great detail. Yeah. So the Cal-OSHA regs, they address 9 different areas. Again, as I've said, some of which you're already doing, but I think the purpose of these detailed regs is to ensure that employers are providing information to their employees to ensure that the coronavirus doesn't spread unnecessarily. So if you go in and you read the regs, you will see how detailed they are, and they tell you exactly what you have to train on, for instance. So the first category is you must draft and implement a COVID-19 prevention program and provide training. And we'll go over each of these areas in more detail in the presentation itself. You have to identify COVID-19 hazards and allow employees and union representatives to help you with the identification and the correction. So in other words, this is supposed to be a joint effort between employers and employees. And the idea is that we give employees some agency, because they are the ones that are actually doing the work in the environment, to help us as employers determine where there may be hazards and what we can correct or what we can do better. Now, number 3 is really important, and we'll talk about why, but you must investigate COVID-19 cases and notify and provide testing to potentially exposed employees. And this is what you've been doing already, but it's also new, because you have to investigate, not only to determine whether or not the COVID case was work-related, was contracted in the workplace, but to determine who may have been exposed to that COVID positive employee, because as employers, you have responsibilities to those folks, and these regs require quarantining and isolation for not only COVID cases, but those who may have been potentially exposed. So physical distancing and mask wearing, we know about that. But these regs really hammer home the employer's responsibility to ensure that physical distancing, mask wearing, proper ventilation, and maximizing outdoor air coming indoors are implemented and followed. Again, this places a tremendous responsibility. I was going to say burden, and maybe to a certain extent it is, but a significant responsibility on employers to investigate and to remedy any area that may in fact be a COVID-19 hazard. All right. And as I alluded to, there are strict quarantine requirements, and the regs set those out. But you have to exclude workers from the workplace if they are what we'll refer to as a COVID-19 case, a positive case, and anyone who's been potentially exposed. And I think while this is something we've been doing, there has been some guidance from the CDC in the past that has suggested if you have an employee who's been potentially exposed, they don't have symptoms, and they're an essential worker, there was some leeway to allow them to continue to stay in the work environment. That's not true anymore, except in a very, very narrow circumstance, which Eric will touch on when we get to his portion of the presentation. Quarantine isolation is critical and required. Again, it reiterates that we have to record, report, and allow access to COVID information. And this is very similar to AB 685, but it does add additional burdens, and it does include all employers. Previously, it was only those employers who had a responsibility to complete a 300 log. Eric will talk about that. All outbreaks must be reported to the Public Health Department. We know that from AB 685. This again just reiterates it. And there is requirements for employer-provided testing. So now employers must provide COVID testing in certain circumstances. There are also two additional areas that I think we'll just touch on today that involve employer-provided housing and employer-provided transportation. There is guidance with respect to how that must be provided, the physical distancing, the sanitation, the disinfection, et cetera. So if you are an employer that provides housing or provides transportation for your workers, these two areas are ones that you're going to want to pay attention to. And we have in fact summarized and detailed them in our book as well.
And as you mentioned, Lisa, a lot of this is the guidance that has been already provided by the CDC. A lot of employers are doing this, but the thing to really keep in mind is this is no longer guidance.
Right.
This is a mandate with penalties that apply to it. Mm-hmm. So it's not just best practices anymore. It's not just CDC guidelines. It is you must do it.
Right.
And there's a penalty for it.
And Eric is right. I think with COVID becoming more extreme, we've got more and more cases. I think it is our state government's attempt to place the burden on employers for disseminating this information and for ensuring that it's followed in order to protect people, in order to stop the spread.
I'm getting a question here. Does this apply to all businesses, or what about really small ones?
It applies to all businesses, every single business, except if the business has one employee that doesn't have any contact with other people, or if the business has employees that work entirely from home. And, I want to highlight this, employees working from home. Theoretically, us in our law firm, we're all supposed to be working from home. And for the most part, the majority of us work from home. However, I am now in our office in order to do this webinar. So this exception, employees working from home, wouldn't apply in our case because we do have access to the office, because we do come into the office, and it does put a burden on the firm to ensure that these mandates are followed. So if you have one employee who doesn't have any contact with other people, and if you have employees who work exclusively from home, these mandates don't apply to you. They also don't apply to any employers who are covered by California's aerosol transmissible disease standards. These are healthcare facilities, hospitals, first responders, et cetera. So what that means is, other than this group of healthcare providers, first responders, virtually every business in California must adhere to this. Okay. So if you take a look at the regulations in our ebook, we have defined a number of the terms in the regs, and I'm going to go over a few of them that I think are critical and important for you to understand because they come up over and over and over again. And in a lot of cases, they mirror the definitions in AB 685. So for example, a COVID-19 case is defined as someone who has a positive COVID-19 test, is subject to COVID-19 related orders to isolate issued by a local or state health official, or who has died of COVID-19. This is the same definition in AB 685 for qualifying individual. So it's referred to as a COVID-19 case. And when I refer to a COVID-19 case, this is what I'm referring to: a positive test, someone who has died, or someone who is subject to an isolation order from a public health department. So this is an interesting statement in the regs. A person is no longer a COVID-19 case when a licensed healthcare professional determines that the person does not have COVID-19 in accordance with the recommendations made by the California Health Department and other regulations and guidelines. And I find this interesting because when we get into Eric's portion of the presentation, you will learn that when you have a COVID case or a COVID exposure returning to work, you cannot require they provide you with a negative COVID test. That was our advice and instruction up until now. You cannot require the negative COVID test. So this definition that says a person is no longer a COVID case when a licensed healthcare professional determines that they don't have COVID-19 is a little bit puzzling, given the fact we cannot ask for a negative COVID-19 test.
Yeah. Why even have that there?
Exactly.
If we learn later that now we can no longer require you to show evidence of a negative test.
Right.
Which many employers were doing up until now.
Absolutely. Absolutely.
And seeing this language would make me still think, well, you know, they're no longer a COVID case unless a healthcare professional says it, but I can't ask them that. So,
It's
Can
true.
can we ask for doctor's notes? Can we ask for physicians to clear them?
I don't think you can, because I think the only way a physician could clear them
would be a
is
test.
if they have a test. And I think what we're going to have to rely on are the mandates in these regs about return to work dates, because they specify in detail how long someone must quarantine before they can return to work.
Yeah, and that's a good question, Janey, because technically, you know, if you just get a note that says this person can return to work, that may not fall within the definition saying the employer cannot require a COVID-19 negative test, but by implication it does. So what we really have to do is they outline exactly what we have to do, which we'll get into later, to allow somebody back into the workplace. And now we just follow that. Yeah. And we document that we followed that.
Yeah.
Folks, I want to jump in here just briefly and let you know that I'm getting dozens upon dozens of questions. So I appreciate all the questions, but we probably won't be able to distill them into many answers in the presentation itself. I'll jump in with the most important ones, the ones I can keep up with.
Okay.
But I want to assure everyone that if you're asking a question, as long as it's technically possible, we will be figuring it out and getting back to you after the presentation.
Right. If we don't answer it in the course of the presentation, we will try and respond to you afterwards. But I think this is put in the regulations really in response to what I've heard a lot of, which is employees who have tested positive with COVID are having a very, very difficult time getting into a doctor who would even perform a test
Yep.
At that point, because docs are overwhelmed, clinics are overwhelmed with just trying to get tests to determine whether or not they're COVID positive. So trying to get a negative test, I think, has been very, very difficult. And at least that's the feedback I've been getting from some of my clients.
No, it's true. But like most emergency regulations, I don't think a lot of this is thought through, because on the other end of it, we'll see later that if you have an outbreak or a major outbreak, you have to test every week.
Yep.
So
Yep.
somehow you have to get those tests.
Mm-hmm. Exactly. And I think some of my clients, what they have done is developed a relationship with a testing facility.
Right.
And so if they want them to have a test, or if they want them to have a negative test, they have been sending them to their specific clinic.
Yep.
And that is something that employers, especially larger employers, may have to consider going forward. Okay, so the next definition that I think is important is COVID-19 exposure. This definition mirrors that of close contact. The definition that we talked about when we talked in our AB 685 webinar about who potentially have been exposed. And a COVID-19 exposure means being within 6 feet of a COVID-19 case, that is a positive case, for a cumulative total of 15 minutes or greater in any 24-hour period within or overlapping with the high-risk exposure period, which we'll define in a minute. And the definition applies regardless of whether or not somebody was using a face covering. So a COVID-19 exposure could mean an exposure even if all parties were wearing face coverings, okay?
And that doesn't have to be in the workplace either.
Exactly. It doesn't have to be in the workplace. But this definition is exactly the definition of close contact that we've been using when we talk about AB 685. And this is an important definition to remember, because you are going to have to investigate each COVID case to determine who is a COVID exposure for purposes of quarantine and isolation. So this is a really important definition to remember. Okay, exposed workplace. Again, this mirrors AB 685 definition of work site, but it means any work location, working area, or common area at work used or accessed by COVID-19 case, again, a positive employee, during the high-risk period, including bathrooms, walkways, hallways, aisles, break or eating areas, etc. And I think this exposed workplace definition, it reads broader than the definition of work site. Hey, where did I go?
Just see the top of your head. There you go.
Oh my gosh, see technology.
There you
We
go.
do the best we can. Okay. When we were doing the AB 685 webinars, we had questions about, well, what happens if the COVID positive employee is on one floor, but they use a bathroom on another floor? Do we have to notify those people? Is that part of the work site? And the exposed workplace definition answers yes. That would be part of the work site. So it's a broad definition. And really it is intended to include everybody who may have been possibly exposed. Oh my God. Sorry, people. All righty. High risk exposure period. Again, this is another important definition. And it mirrors what we were talking about in AB 685. For a person who's developed symptoms, the high risk exposure period is 2 days before symptoms were first developed until 10 days after symptoms first appeared, and 24 hours have passed with no fever, without using fever-reducing medications, and symptoms have improved. For someone who has tested positive but doesn't develop symptoms, the high-risk exposure period is 2 days before until 10 days after the specimen for their first positive test for COVID-19 was collected. This again is another important definition because it will overlap with and inform your investigations about who is a possible COVID-19 exposure in the workplace. So when we get to the investigation section, we'll kind of bring all of these definitions together and you'll understand the importance of having this information, knowing this information, and why you need to investigate and determine as best you can all of this information. All righty, so here's the biggie. All employers must draft and implement a COVID-19 prevention program. The regs say it could be a standalone program, kind of like your employee handbook would be, or it can be part of your injury and illness prevention program. The regs, though, are very clear as to what must be included in this program. So communication is a big deal in these regulations. The program must include ways that employees can communicate whether they have symptoms, whether they've been exposed, even outside the workplace, whether they've been exposed, and to bring to the employer's attention any potential hazards they see. You have to include procedures for accommodating employees with medical conditions or other comorbidities that may put them at increased risk. So what that means is you've got to really think creatively and broadly within your workplace to determine how you may best be able to isolate people with medical conditions or comorbidities if, for example, they're unable to telework. Is there a way to isolate them so that they can continue working, but that they're not unnecessarily exposed?
Yeah, and I can see where this going astray because you want to make this a broad policy, but you want to still stay clear of assuming medical conditions and assuming comorbidities and implementing that without the employee letting you know that they need an accommodation. So yeah, you need a procedure for handling it when it comes to your attention, but you don't want to assume that somebody has, a medical, well, somebody's pregnant, right? Do you say they have to telework, right? Somebody is over, 65, I mean, those are the kind of things you can't do because it's a violation. You have to be careful with.
Yeah, and I think it goes along with what our general advice is for accommodations and disabilities anyway, is you have to accommodate when you know about the disability. So if you've got an employee who comes to you and says, hey, I have diabetes or a heart condition and I'm concerned about my risk, what can we do? That will prompt you to explore accommodation options, but you're not required, nor should you, go out and start speculating about who may need an accommodation.
Right.
Lisa, what if you know an employee has diabetes because of other episodes where they've explained it to you prior to this COVID outbreak? So you already know that they have a condition that fits this. What does that do to the obligation of the employer?
I'm sorry, go ahead and answer. You and I will both have the same answer. Go ahead.
Well, I would say it does nothing unless they ask for an accommodation because of COVID risk.
That's why I love you, Lisa. We always have
we have the same brain.
We share a brain.
But again, that's what you do. You cannot assume. You cannot assume.
Even if you know they have the medical condition, your obligation does not arise until they ask for the accommodation. Right. Which is probably what part of the procedure is to make a request to a specific person if you need an accommodation. Yep,
exactly. So your COVID-19 prevention program must have information about COVID testing. So if your organization already provides testing, You have to describe the testing policies and procedures, the reason for the testing, and what will happen if there is a positive test. And as you'll learn a little bit later in this program, employers are now required to provide testing in certain circumstances when there's an outbreak or a major outbreak. So you'll have to make arrangements to be able to provide that testing going forward. You have to provide information about COVID-19 hazards and your policies and procedures about how you're going to alleviate those hazards. It could be PPE, it could be the change in policies and procedures, it could be the change in work shifts, it could be all sorts of a manner of ways to deal with these hazards. Again, this is not anything new. This is something that I know all of you have been doing and thinking about already, but now it must be written down. Now it must be made available to your employees. So you have to think about the hazards, your workplace specifically, and how you're going to eliminate some of those hazards. There is now a requirement that you screen employees. Now, you don't have to screen them as they come in the door, although you can. And if you do screen employees regularly as they come in the door, there are requirements for that. For example, everyone must be wearing face coverings. You must use a thermometer that doesn't touch the forehead, those types of things. But if you don't have that in place, you must implement a self-screening process where employees can screen themselves at home. So for example, some of the questions would be, do you have a fever over 100.4? Have you been in close contact with someone who has tested positive? Have you traveled outside the country? So there's a series of questions that are typically asked. You would have to implement that for at-home screening of employees.
And is this do you think this is a daily screening?
It doesn't say.
Yeah.
It doesn't say, but I imagine that it is.
Yep.
So if you are doing a daily screening as people enter the facility, I think you should also be doing a daily self-screening. How that gets done practically, for having employees do it at home, do we have them, do a checklist and turn it in as they come into the workplace? Do we take their word for it that they've done it? I'm not usually a fan of taking the employee's word for it, but there's no regulations or guidance as to how the self-screening is to be implemented.
Yeah, and there's also some wage and hour concerns in doing this, because if you are implementing a policy for self-screening, what that means is somebody's at home checking their temperature before they get in the car to come to work. Is that considered work for compensation? And the likelihood is that it is.
Yep.
And then
I was going to ask, on top of that, what if they claim not to have the equipment to do it? I mean, are we required to purchase thermometers? I know that sounds silly, but
no, that's exactly what I was going to say. So you read my mind. It's a reimbursement issue, right? So if an employee, and part of your policy is that you shall self-screen before you come to the office, an employer may be required to reimburse a reasonable amount for the tools to do that, which would be a thermometer. Is that the full cost of a thermometer? Probably not, because they also have it for personal use. Is it a portion of that cost? How much does these touchless thermometers cost? I mean, last time I checked, it was like $15 or something like that. You pay $5 of it. And so it has to be part of if you're going to go self-screening, you really have to think about that, because now it's going to be in your written policies and informing employees of how that's handled from a wage and hour perspective. Yeah.
So there's a lot of considerations when determining whether you're going to implement a self-screening process or a screening process when folks come into the facility. Okay, and it goes on and on. You have to have a description of how the employer will comply with physical distancing requirements. Obviously, we are all trying to physically distance our workforce, but you have to identify how that's going to be done. And you must now provide face coverings and other PPE. It's the employer's affirmative obligation to provide face coverings. Excuse me, I have a cold.
And clean face coverings. So this isn't just like one set of face coverings. It has to be, clean face coverings.
Yep.
So is that, and now that they're more available, that's probably why they're adding this, because we have the PPEs available to employers.
Yep. And the prevention program must also describe how the employer will respond rapidly and effectively when COVID cases occur. And as you recall, AB 685 requires within 1 day you notify employees who were potentially exposed. These regulations do the same thing, not quite as broadly, but they do the same thing. So you do have to describe how you are going to respond quickly and effectively, and the ways you're going to reduce and prevent the transition. And number 8, this is important. You have to describe your investigatory procedures when you have a COVID case, including how you will provide notice to potentially exposed employees. And I think it should also include an expectation of all employees that they will cooperate with this.
Yep.
So for example, if you have a COVID-19 case, you're going to want to know information about where they contracted it. Were they at a gathering over the weekend? When did they first get symptoms? Have they taken their temperature, and when did they first notice an elevated temperature? All of these things are important facts that you need to know in order to carry out your obligation under these regulations, because you have an obligation to quarantine all exposed cases. And in order to determine who is an exposed case, you have to know when symptoms were developed, what the highly contagious period is, etc. So you must develop investigatory procedures, one of which may include a contact point. Who is going to do the investigations for your company, right? All right. And then you must include information about your training program, because these regulations do require that you train your employees with respect to certain portions of this program, and we'll talk a little bit about that. You also must maintain records of the steps taken to implement this program. And when we were kind of chatting about what that would look like, does it mean we need to document every time we talk to a COVID case, a positive employee, and document what they tell us about their symptoms, what they tell us about when they first tested positive, etc.? And it probably does. Yep. It probably does mean that. And I say that because this is the roadmap for all employers to use if they are ever faced with a complaint or a lawsuit alleging unhealthy and unsafe workplace, right? You want to be able to show that you have implemented everything that the regs and other agencies require of you. And that's going to be part of any defense that you will have, either to an employee who brings such a complaint, or even to OSHA, who may come in and allege violations.
I think, and I agree. I think it absolutely means you have to maintain these records of these individual potential cases while you're investigating it, because how else are you going to document the onset? What was the date of the onset of symptoms? What was the date of the positive test? Right. Who you've been around in the there's no other way around it other than documenting it, and in order to implement, especially the return to work component of it.
Right.
So,
right. And obviously, all of these records that you keep are confidential. They do not go in the personnel file. They go in separate medical files. but I do think all of this information is going to be critical for you when you investigate and implement the isolation requirements.
Yep.
Okay.
Lisa,
Yeah.
one of the things that we were up against with the holiday coming up is people who are traveling. Even though there's mandates to not travel, some people still did. And so we were tossing around the ideas of coming up with a policy as part of this prevention program of mandatory quarantine for people that go outside of the state or out, any distance. What do you think about that?
Outside of the state. What do you think about that, Eric? I'm more comfortable with outside the country, perhaps.
Yeah,
Okay.
I mean, I think a traveling policy of quarantine is fine, but the problem with it is how you implement it in a fair, on its face, non-discriminatory way.
Right.
So, if it is it, outside the state, well, okay, somebody comes back and says, well, I, got in a plane from LAX to San Francisco. Why doesn't it count for that person? Right. So I think it can be done because there's, I think, a reasonable basis for quarantining somebody who's been traveling, especially on planes. But the trick is doing it in an even, non-discriminatory fashion. So it would take, some artful craftsmanship to do that.
Yeah, and I think maybe, Eric, what we would want is to include in the prevention program an obligation on the part of our employees to disclose when they are traveling via airplane, right?
Or public transportation, of any sort, I guess. I mean, if somebody's on a bus, right?
Yeah, any kind of maybe public trains, planes, etc. But all of this should be part of the program. And while the template that we're putting together will include all of these requirements, it's going to be up to the individual employers to really customize it for their workplace.
Yep.
Yeah, they'll have to work with their lawyers too. Hey, folks, just as a matter of update, so you and Lisa, you and Eric know too, we're getting a question about every 30 seconds.
Wow.
I'm looking down there and I see 116 in the Q&A.
Yeah. So we actually disabled the chat from asking questions. So I was going to commit to everyone that would answer all these questions in writing, but I think what's going to happen is at the end we'll give you an email, and if you send us an email with a question, we're gonna go that way. The volume's just too overwhelming. Don't worry, though. We're going to be around on this for a long time. I think we're going to have a core presentation of this, and Mike was just texting me suggesting a Q&A webinar, and so we're going to remain on this and be available to you. But we're going to probably ask you, we're not going to try and answer all these questions at the end. We're going to probably ask you to just email us any questions that you still have after the presentation's over, and we will definitely get back to you.
Yeah, absolutely. And at this point, this is such a new law. There's not a lot of commentary on it, and there are no interpretations of it. So what you're hearing from Eric and I today is how we interpret it based on a reading of the language, and we expect to have more guidance as to enforcement going forward as well.
Yeah, okay. And the language, I understand where all these questions are coming from, because the language is in many places obscure.
Yep.
So, which is not surprising for emergency orders.
Yeah.
So it's, a matter of, trying to figure out what the best practice to where it's most likely going to fall.
Right.
Yep.
I just, one comment caught my eye. It says, I traveled via train to a Trump rally. Don't quarantine. It's like, sorry, there's nothing we can do.
All right. Now let's move on to really what is the second and third areas covered by these regulations, and that is the identification and evaluation of hazards. Now, this is not really anything new. These are things that you have been instructed with respect to other regulations and laws like AB 685 to identify all interactions, areas, places, activities, processes, equipment, etc., that potentially expose employees to COVID-19 hazards. You've been doing that. What this regulation does is it mandates it be done, and it mandates that you put the process in your prevention program, right? So it's requiring you to A, do it, B, really think carefully about how you're going to do it, where you're going to do it, perhaps instruct your employees to contact you immediately when they see an area or an activity or a process that should be done differently because it may pose a hazard. So again, it's encouraging all employers to think creatively and broadly on how we're going to protect our employees in the workplace. So we want to reduce hazards, not only in places where we work, but where we meet, where we come in contact with each other, for example, the lunchrooms, the bathrooms, the elevators, etc. But we also must identify hazards to other people coming into our workplace, customers, clients, vendors, the public, etc. So think in terms of protecting your employees while they're at work and protecting members of the public when they come into your facility. And then that also needs to go into your prevention program as well. How are you going to do it? How often are you going to do it? And as you'll see, this law requires that you do this investigation every time there's a COVID positive case in your workplace to determine whether or not, with respect to that particular case, there was anything you could do differently. And if the answer to that is yes, then you must implement that change. So it puts a heavy burden on employers, not only to think about it on the front end, because it's got to go in your prevention program, but to think about it continuously and to make changes continuously in response to COVID-19 cases and other issues in the workplace.
If I could jump in quickly here,
Yeah.
we got a lot of questions about the relationship between this investigatory process and a workers' comp claim being filed.
Yeah.
So it's important to note that you don't necessarily have a workers' comp claim, even if you do an investigation and find that there's a work-related injury. If you know that someone's claiming a work-related injury, then you have to provide that person with the claim form and notice of their rights, right? If you know that they're claiming a work-related injury. But that doesn't mean they necessarily have to file one, right? So the two things are not necessarily always linked. Eric, you and I have talked about this quite a bit.
Yeah, and I think the lines are continually blurred, especially with this investigation requirement under these regs, and the notices that have to be given about workers' comp rights and everything that goes with it. Because these notices have, if it's a work related, you can file a workers' comp claim. But as you're investigating and finding out where they think they got it, the chances are going up that they're going to give you information to where you're closer to knowing it's work related than it would be to just say, oh, you're sick. Oh, don't tell me anymore. Okay. Go home and quarantine. You don't get to do that. You have to investigate. Okay. You're COVID-19 positive. Where do you think you got it? Who were you in contact with? Were you in contact with people at work? That kind of thing. Now you have to invest and not only investigate it, you have to document that investigation. Mm-hmm. So the chances of you getting out of providing a claim form are slimming down, I think. Although I stay out of workers' comp as much as possible, but I hate to say it, but I that's the way I see it from here.
Yeah, I agree. Yep. I agree.
And I know Mike is twitching over there.
So as part of your identification and evaluation of hazards, again, and we've talked about you must allow the employees and their union reps to participate in the identification and evaluation of hazards. And again, this needs to go in your handbook, in your prevention program. allowing employees and encouraging employees to bring these things to your attention. And there is a heavy emphasis on ventilation systems, and for indoor locations, determining whether or not there is any way to get outdoor air flowing into the facility. And this is an affirmative obligation of employers to evaluate their ventilation system and how their airflow is occurring. And this may mean that you call your HVAC guy to come in and evaluate your system. That's what this means. If you are a tenant in a building, it probably means you call your landlord and find out whether or not the system meets the requirements of these regulations. So it's an affirmative duty. You can't just assume that you're doing everything you can. You've got to find out. You got to find out. And then to make matters even more complicated, employers must review all local and state orders and guidance and implement them in the prevention plan. So if this wasn't enough, now you need to include all local, state, federal orders and guidance in your plan. We are going to do our best to include the state orders for sure. Each employer, though, will have to look locally for their local safety orders, their local sick leave ordinances, those sorts of things. But again, OSHA's putting a significant responsibility on employers here to do the heavy lifting to really help prevent the spread of coronavirus in the workplace. I mean, that's the purpose of all of this. Okay. And then, as I think you've been taught to do or instructed to do, you've got to review your policies and procedures on a regular basis to determine whether or not they need to be modified. And if you have a COVID positive case, you're going to have to look at your policies and procedures every time you have a COVID positive case, again, to determine whether or not there is something you could have done different or something you can change to ensure that somebody in this person's position is not exposed going forward. And again, periodic inspections for unhealthy conditions. Again, all of this is things that you've been instructed to do before, perhaps are doing now. What these regulations, though, are doing is A, mandating it, and B, requiring that you think about it in enough detail to put it in your prevention program. Okay. All right. Investigating and responding to COVID-19 cases in the workplace. Now, remember, a COVID-19 case is a positive case. And this is what we've been alluding to in terms of the investigation the employer must conduct when it learns of a positive case. So you have to figure out what's the date and time the positive case was last present in the workplace, the date of the positive test, if possible, the date of the onset of symptoms, determine whether or not this positive case occurred at work or occurred somewhere else, etc. And then with that information, you need to determine who may have had a COVID-19 exposure. Now, remember, COVID-19 exposure is defined as being within 6 feet of a COVID case for 15 minutes within the last 24 hours. So that's going to require you know who was present at the workplace when this COVID-19 case was there, when their symptoms developed, what the high risk exposure period is, and then determine who are the group of people who fit that COVID-19 exposure definition, because you have obligations related to them.
This is no small task.
It's not.
I mean, I can see.
How are you supposed to do that possibly in a million years? I don't get that.
I mean, you have to document the best way you can, but this is the problem I see.
Mm-hmm.
You have somebody who has a COVID-19 case, and we're supposed to keep that confidential, right? We have to investigate. So now we go into the workplace, and hopefully this COVID-19 case remembers everybody that they were around. But if they don't, now we have to start asking people who were there around, where they were sitting, how long they were there,
Yep.
which really kind of links the who the COVID-19 case is, right? And you have to dance around that and document it. So this is, one, it should be within every organization, maybe 1 or 2 people that is responsible for it,
Right.
because they're gonna have to get good at this and about properly navigating it and documenting it and keeping it medically confidential. This is no small task that is required as of today, assuming it's been passed, which it will be.
Right. And we run the risk sometimes of saying, okay, well, it's hard to figure out, so let's just throw everybody into that COVID-19 exposure group. The problem you're going to have with that is these regulations require quarantining of folks who are COVID-19, meet the definition of COVID-19 exposure. So, at the risk of having to quarantine, all departments, as one person in that department becomes ill, this investigation even becomes more important so that we're not quarantining everybody. Because if we quarantine folks, and Eric will get into this, there will be or might be some obligation to continue to pay them for the quarantine period. So this is no small task. It really isn't. And I like Eric's recommendation to have 1 or 2 people who are trained in doing this, doing it quickly, and ensuring that we're identifying the COVID-19 exposure employees. Okay. So just like AB 685, you've got to give notice to the COVID-19 exposure person or group within 1 business day. And of course, you can't identify who the COVID positive employee is. So you have to let all employees know who may have had COVID-19 exposure and their representatives know they may have been exposed. You also have to let independent contractors and other employers present at the workplace know as well. And this is a little bit different from AB 685. In AB 685, employers weren't required to let independent contractors know. They were only required to let their employers know. So this notice requirement is somewhat broader, but at the same time, it doesn't require the bells and whistles AB 685 letter that we've drafted and that you have a copy of that must go out under that law. It's really more consistent, I think, with what everyone was doing before AB 685, which is letting folks know they may have been exposed.
But what this does mean is that for employees, giving that notice, you probably should just be doing that now. And we have a template for it. So it was supposed to be January 1st, but now that we have to start doing that as of today, give that notice now. You don't have to give that to independent contractors with, like what Lisa said, with all the bells and whistles, but to employees, you should start doing that now. Because you have to do it in a month anyway, with the full notice. So you should start doing it.
Yeah. And that will become part of a training anyway. You're going to have to train your employees on the benefits that they are entitled to should they test positive or have to quarantine.
Yep.
All righty. So in addition to notifying employees who may have been exposed, you have to offer COVID-19 testing at no cost to employees during their working hours. So this is new. This is a new requirement, and I don't have good recommendations about how to implement this, because what I have heard from most of my clients and people trying to get a test is it's very, very difficult. It's very difficult to get in and get a test unless you have symptoms. And what this new law is saying is you've got to test those folks who were exposed, regardless of whether they have symptoms. So it may be necessary to develop a relationship with the testing facility and have them available to send your employees to during working hours so that they may be tested.
Which means they should be paid during that time.
Yep.
It's a compensated time now. And now there might be, a lot of employers offer health plans that have these free COVID-19 tests. Like for example, Cigna. Well, you send an email to them and they send you the test in the mail. You get it within a day and you send it back. That's free. It's in the health plan. That might check that box as opposed to sending somebody in. Because these are people who are quarantined already.
Right.
So I think that might qualify, don't you?
I think so. Yep, I think so. And I'm getting the nudge that we are behind on our slides.
Okay.
So I
want to interrupt. Keep going.
I'm going to slow you down.
I am always accused of talking too fast and talking too much. So let's see if I could speed it up a little bit more. Again,
but I got to ask you, Lisa. I got to ask you one question that everyone's asking: can we require people to get a test?
For what purpose?
A COVID test. Can we require the employees to get one if they don't want to?
Oh, so you have, so this requires that you offer COVID testing. If they say no, you do have the right to exclude them from the workplace, right? You either get a test, and if you're negative, you can come back. But if you're not going to test, then you've got to quarantine.
Yep.
And that's perfectly acceptable.
Right. But you can no longer require a test to come back to the workplace.
Right.
So to the broader answer to that, as a requirement to come back to the workplace, you cannot.
Right.
And there's certain circumstances where the employer is required to test these employees for outbreak purposes. And that might imply that they have to go home if they're not going to test.
Right. And for purposes of this requirement that we're talking about right now, offering testing to exposed employees, I think you offer it. If they say no, because they're an exposed employee, these regulations say you've got to quarantine exposed employees anyway.
Yep.
Right. So in any case, alrighty, training and instruction. So you do have to have a training session with your employees. It must be effective training and instruction. There's no real guidance on the length of training or who can perform the training, but there are things that must be included, one of which is your COVID-19 policies and procedures. The second is information regarding COVID-19 related benefits, which they may be entitled to under federal, state, or local law. This is the AB 685 notice benefits that law requires that you provide to people. It's our recommendation that you couple training with the rollout of the prevention program, and then have folks sign a receipt of the prevention program and sign into the training. That way everybody's hearing the same information at the same time, and you can underscore the importance of reading and adhering to the provisions of the prevention program. All righty. So here's more things that must be in the training. And this is what I think is kind of funny about these instructions, is they are very, very specific. You must instruct that COVID-19 is an infectious disease that can be spread through the air when an infectious person talks or vocalizes, sneezes, coughs, or exhales, etc. This will be in our program prevention template. But again, this is the language that you're required to use in training. And again, we've got to emphasize the importance of social distancing and the importance of wearing face coverings. Again, more training information and specific things that employees must be told, including a reminder of frequent hand washing for at least 20 minutes and the use of hand sanitizer. And I thought this was kind of funny. Employees must be instructed that hand sanitizer does not work if the hands are soiled. So wash your hands and then sanitize them. So these are the things that have to be included in the training. Again, I think I would recommend, if it is possible, to roll out the prevention program and do the training somewhat simultaneously if you can. Okay. And then tell employees, don't come to work if you're sick. All righty, I am going to hand this over to Eric, so you could get to really what is the even more difficult part of adhering to these regulations.
Yeah, so, and I have about 20 minutes to do this, so I'm going to highlight some of the really important aspects. And the first here is about physical distancing, and everybody's like, no doubt, Eric, we've heard about this the entire time. 6 feet, except with the employer can demonstrate the 6 feet separation is not possible. The difference now is, like I said before, this is not a guideline. Now we have to police this in the workplace, and it is not easy. The reality is people come into work in the morning, people are keeping their distance. The day goes on, people get tired, they start getting closer, they want to start pulling off their masks. And those not only end up being a violation of a guideline, it's a violation of a reg now. And if some people are going to, and I've already heard, well, OSHA, they're not going to really monitor this, what are the chances of this happening? And I will, that's what people said at the beginning, and it has been happening. And they have geared up, and they do have a big budget now, and they have hired more employees and investigators, and the penalties are real. General penalty is, and now, we have OSHA and Cal OSHA. And OSHA is federal, Cal OSHA is California, and it is no surprise to everybody that Cal OSHA is more restrictive than federal. It's just the way California is. And so are the penalties. So general penalty, $13,000 and a little above that for general. Serious penalty, 25 grand. Willful can be up to $132,000.
Per violation.
Per violation,
Yeah.
So it's repeated. So we're talking 6-figure types of violations here.
Mm-hmm.
That can apply to these. So this is no longer, not only is this difficult to implement, it's going to be really easy to get wrong.
Mm-hmm.
It's going to be really easy to get wrong. You can go to the next one. I'm sorry.
Sorry.
So employers must evaluate whether it's possible to physically distance other than in the workplace. So what does that mean? Obviously, remote work. And I know that everybody was really excited. September, October, okay, everything's starting to go back to normal. Let's bring everybody and mandate them come back to the workplace. Now, you have to actually actively consider whether they can work remotely, right? Not just because you want them in the workplace, but if they can work remotely, this is an active duty to say, can they just telework and get their job done? And there's a lot of employers out there that are like, well, I want people in the workplace. Well, now maybe you can't, because they can get their work done by teleworking or other remote work arrangements. And so that's a reality now. We'll go to the next one. Again, face coverings, not only now you have to provide them, they have to be clean, they have to be maintained. So just handing out one, per employee and calling it a day is not an option. You have to keep them available. So probably those disposable ones that everybody uses once a day. And that's probably, where the budget has to go to.
Yeah.
Exceptions to face covering requirements. And this is important because we get into, potential, well, let me start here. Exceptions can be an employee's working, they're in their office, they're not around anybody, or they're eating, drinking, that type of thing. And which, all makes sense. But people, when they're in their offices, tend to forget, and then they walk out.
Yeah.
So now people have to understand that once you walk out of your closed office, you have to put that mask back on. And the eating and drinking, should you even be having a eating and drinking in a break room? Should you be using the break room? Should you have alternating schedules for break rooms? Those are things you have to consider. This is what I was getting to. So employees who cannot wear face coverings because of medical or mental health conditions. Now, this does come up a lot. And what do you do when somebody says that they have a medical condition or a mental health condition? Do you just automatically say no and get out? No, because this falls under ADA and FEHA. So you have an active obligation to engage in an interactive process to see if you can accommodate in different ways. So you have to think about it. And I think that when somebody does say it's because of a medical or mental health condition, that you can require a medical note. What do you think, Lisa?
I think so. Yes, I do think so.
And I think you do. Obviously, if they're, saying it at the beginning of a work day, you don't make them wear the face covering if it's for a medical or mental health condition until they get you a note. But you give them a timeline to get back to you with a medical note.
Mm-hmm.
I'm being asked, what if you have plastic barriers instead of a 6 feet separation?
There's no exception to the 6 feet separation, right? I didn't see one. Lisa, did you?
No, except where it's not possible. And so I think you need to really look carefully as to whether or not it's possible or not, or whether it's just easier to put up the barriers than to separate people by 6 feet. And I think you've got to separate people if it is at all possible.
Yeah, and it's a good question because most people they have cubicles and everybody popped up, the plastic dividers. And if you have a larger office and you can space people out, you should be spacing them out. If you can't and there's no option, then you probably fall into that restriction. It's not possible and they have to be as far apart as possible.
But I would recommend that you document what you did to try and adhere to the regs.
Yep.
Okay.
Next, an employer cannot prevent an employee from wearing a face covering. Now, like, for example, if somebody is in their office and they choose to continue to wear their face covering, going in and say, hey, people they don't need to see your face covering, take it off. You can't do that. If they want to wear their face covering and they're and they're isolated and they feel more comfortable, you cannot tell them to take off that face covering. You have to inform non-employees like customers, vendors of the face covering requirement. We've all been hopefully doing that. And implement the policies to minimize exposure. Nothing new there. Disinfection and cleaning. So implementing and disinfection procedures, identify and regularly clean and disinfect frequently, touch surfaces, prohibit sharing of personal protective equipment. I mean, come on. Procedures for disinfecting and cleaning areas worked. Now, whose obligation is that? Are you going to wait for janitorial services, or is it more active than that? And I think it's more active than that. Yep. Who's in charge of that? Do you have a service that comes in and does a full disinfection? Because janitorial services, they may not be doing a full disinfection process. And whoever you should be documenting who's doing that, when they're doing it, and probably the timing that it's done.
How frequently?
How frequently? And do you just tell the employees to wipe off their desks and everything and where they are? That's not enough. It's the employer's responsibility, not the employee.
Right.
The need for personal protective equipment in their work. Yeah, no, nothing new there.
Yeah.
We transition in the workplace, impose. Well, okay. So you have to ensure that COVID-19 cases are excluded from the workplace until the return to work requirements are met. That's really important and detailed. We'll get to that in a second. Employers must exclude employees with COVID-19 exposure from the workplace for 14 days after the last known COVID-19 exposure. Now, exposure is, as Lisa already defined it, is pretty specific between the time symptoms are onset and there's that exposure period. But I think you need to fall on a more conservative approach if people are exposed and quarantining them. For example, if somebody says, my wife was carpooling with somebody she does every day, and they're in the car for 30 minutes, and he just said that he is COVID-19 positive. Is that technically an exposure under OSHA guidelines? No, it's really not yet. But the chances of that wife having it and giving it to her spouse is extremely high. Right. And do you quarantine that person? And my suggestion is yes, you do.
Yeah.
Even if they have not tested positive, even if it's just, even if the husband hasn't tested positive yet, you should probably be quarantining that person. What do you think, Lisa?
I agree. I absolutely agree. because the idea and the purpose of these regulations are to stop the spread.
Yep. So, okay. For employees excluded from the work or otherwise able and available to work, employers shall continue and maintain, and I'm reading this because this is important, and maintain an employee's earnings, seniority, and all other employee rights and benefits. What does that mean? It means that if somebody is excluded from the workplace because of a COVID-19 exposure or a COVID-19 case, they have to maintain their pay, okay? And how do they do that? Well, you have options. Right now, you have FFCRA if it hasn't been exhausted yet, and it does sunset at the end of this year if it's not extended. If that's not available, then it says you can go to sick pay to pay for that period of time. And it doesn't say PTO, it doesn't say vacation, it says sick pay. So something that your policies specifically identify as sick pay, you can use for that payment. If those aren't there, it comes out of the employer pocket to pay. It's a new type of pay leave for that quarantine period. And that's assuming that they can't work remotely. If they can work remotely and they're quarantining, then you don't have to pay extra, or they don't just take the time off. If they can work and they're able to work, they can work remotely. And it does not apply for a period of time during which the employee is unable to work for reasons other. So if there's another reason that they cannot work, they had already had a planned vacation, they already had, some other planned time off, then it doesn't qualify. And it doesn't apply when the employer demonstrates that the COVID-19 exposure is not work-related. Now, this burden is now on the employer. So you, employer, have to argue it wasn't work-related. You have to prove that. There's a presumption here that it is work-related. And so that's going to be a high bar. So chances are you're probably going to be in a place where you use some type of paid sick leave. If not, employer pays out of pocket.
Right. And this just highlights the importance of doing the investigation.
Yep.
So we can identify whether or not it was work-related or not.
Yep. And you might be in a situation where the employee admits, I got it when I was on vacation. I wasn't even in the workplace. And so those happen, but there's going to be a presumption against you.
Yeah.
Okay. So this just says employers can have greater benefits, collective bargaining agreements, that kind of thing. So no less than these requirements, but you can have better. The employer should provide the employee the information and benefits at the time they're excluded. So it's the AB 685 requirement, all of those bells and whistles when you exclude an employee. And that is immediate. So once they're excluded, that notice must be given to them. This isn't a 24-hour period. It's at that time.
Right.
COVID-19 cases shall not return until, okay, so this is, as opposed to requiring a COVID-19 negative test, this is now what you have to do. And this is what you have to document. And a lot of this has to do with relying on what the employee tells you. So this is the requirements. At least 24 hours have passed since a fever of 100.4 or higher has resolved without the use of fever-reducing medication. So how do you know that? The employee tells you. Have you had a fever in the last 24 hours without fever-reducing medication? Oh, no, not at all. Okay. So you record that. COVID-19 symptoms have improved. What does that mean? Could they still be coughing or, yes, they can if it's improved, right? So if they haven't had a fever and they still have symptoms, but their symptoms have improved, potentially they can come back. At least 10 days have passed since COVID-19 symptoms first appeared. So, so you have to document when they first appeared. Yep. So that has to be in, and that's obviously in a medical confidential file when you do that. COVID-19 cases who tested positive but never developed COVID-19 symptoms shall return to work until a minimum of 10 days have passed since the date the specimen was collected. So you have to record that. A negative COVID-19 shall not be required for an employee to return to work. Now, I think this exactly does say you cannot require a COVID-19 test to return to work, but the language is could be twisted to say a negative COVID-19 test shall not be required, meaning the employer, you don't have to require that, but you may. I guess that could be argued. But I think that the interpretation is correctly, you can't do it.
Right.
And this is just bad drafting on the part of the emergency legislature. If there's no violation of local or state health officers' orders to isolation, quarantine, CalOSHA may, upon request, allow employees to return to work. Now, this is the exception. If the removal of an employee would create undue risk to community health and safety. So there is an exception to returning to work outside of what I just mentioned. It's going to be very rare. This is going to be like a some type of public health officer, somebody who cannot be replaced has to come back during that period of time, and you have to put in processes that isolate them and protect the general public. But I think this exception is going to be very rare.
Right.
You have to keep record of the COVID-19 cases, name, contact information, occupation, location, everything we've been talking about. And that's why I say have a person who does this, or a couple of people, depending on the size of your organization. Because this is going to be, there's been a lot of reporting of cases in the last month or month and a half I've seen. I get calls every day from clients. And so this is not going to go away quickly until a vaccine is out there. So somebody needs to be ready to do this as part of their job on a regular basis. Infections identified by a local health department as a location of COVID-19 outbreak. 3 or more, as we've said, and we've and that we already knew, for a 14-day period, and you have that obligation which continues for reporting for that 14-day period if there's unless there's no new cases. If a worksite is identified as one with multiple infections or outbreaks, the employee must provide COVID-19 testing to all employees at the exposed worksite, except for employees who were not present during the period. So now you have to provide that testing for all the employees. What does that look like? Is that rapid testing? Is that testing that takes 3 to 5 days? And we're going to talk about what it looks like for major outbreaks. And I think it might be rapid testing because of the timing. So all employees in the exposed workplace shall be tested, then retested 1 week later. So a 3 to 5 day turnaround makes little sense in a test if you're getting tested 2 weeks in a row. It might be a rapid test that you're doing. And those are typically about $150 a pop, right? Let's see. After the first 2 COVID-19 tests shall provide continuous COVID-19 testing of employees who remain at the workplace at least once per week or more frequently. This is a lot of testing, and it's very frequent. So unless you can get a turnaround of a day or two, it might be rapid testing, depending on who your provider is. Employer has to investigate and determine the workplace factors that contributed to the COVID-19 outbreak. So now you have to figure out why you messed it up. What got messed up? And you have to document why you messed it up and how you can do it better. And you have to put that on a piece of paper. I hate this. I really do. But you have to do it now. Where did we go wrong? How did this happen? And why did it happen with all these other regs that we've talked about that said all the other things that we have to do to prevent it? So go ahead. Okay. The review of the investigation must be updated every 30 days when the outbreak is continuing or in response to new hazards or information. Employer must make changes to the workplace when hazards are identified. Okay.
Right.
It's required by AB 685. The regulations confirm the employer's requirement to report outbreaks to the local public health within 48 hours after the employer knows, or with diligent inquiry would have known. So it's not just know, you would have known. So you can't turn a blind eye to it. And it's within 48 hours. Major outbreak, 20 or more COVID-19 cases in a 30-day period. And again, that ceases only if there's no new cases within within 14 days. When there's a major outbreak, an employer must provide twice a week COVID testing. I think that's absolutely rapid testing at this point. For the exposure during the relevant 30-day period. All requirements related to investigations during outbreak apply during major outbreaks. Employers should notify the local health department, obviously, and you're going to have an ongoing obligation to report new cases as you go. Let's see. Require the outbreak. Employers must also take the following filtrate. Okay, so filtration units have to be inspected. Who does that? Well, your landlord hires somebody, or you hire somebody to inspect their filtration units. Employer must determine whether there's a need for respiratory protection and implement any other measures. And this is for major outbreaks. Now, if the employer provides housing, Lisa talked a little bit about that before. There's more requirements here. It's unusual, but when you do, you have to have prioritized housing assignments based on family units, ensure physical distancing, obviously, increase use of outdoor air, and implemented a disinfection, screening, and testing process for these people. So what's the screening process? Again, is it self-screening? Are they screening when they come into the work site? And transportation. That's also not terribly frequent, but it's also those employers that make everybody park in a particular parking lot that's a mile away, and everybody gets on a bus and comes in. So you have to provide and there's other ways employers do it. So you have to provide the physical distancing, open air. I guess you roll down all the windows. And
that's what it says. Actually,
you roll down all the windows.
Yeah.
And a disinfection process for every time there's a trip,
Yeah.
So who's cleaning up, the vehicle, the bus, the car. So I think that is it.
Yeah, and we rushed through the last two, but if you have questions about housing or transportation, you can look at our ebook or send us some questions.
Right. So here's a slide that's got the, do we have an email on here to, you can send it to the Sullivan on comp at sullivanattorneys.com. If you have questions, we got, like I said, a question every 30 seconds in this webinar.
Yeah.
And we can't answer them all. So if you have a question that didn't get answered, send it by email, help us. We'll probably prepare a fact sheet and we'll certainly address it. Also, we were rushed. This material is just vast. This is just such a huge stack of regulations, and to absorb and implement it all is just a gigantic process. So look, we're going to be back in one form or another on this. And
no way around it.
We're going to keep at it until we've gotten through and answered all the questions and everyone feels comfortable and ready and we have our samples and the whole thing. But for now, we are out of time.
Yep. Hey, I did that in 22 minutes, people.
Nice job.
Yeah. So I want to thank Lisa, Eric, and Janey, and myself.
Thank you, guys.
For attending.
Thank you, everybody.
Thanks for listening, folks, and we'll talk to you next time.
Bye.